Unlawful display of a weapon in Seattle or Washington State. Are you charged with that? Are you just interested in what that is? If so, this is the right video for you. Because my name is Lance Fryrear, and I am the defender of justice. Defender of justice. Defender of justice. Defender of justice. I don't normally look like this. I look like this. And that's because I'm a defense attorney. And I own a law firm in Lynnwood, Washington that's been defending people charged with crimes, including unlawful display of a weapon, for more than 20 years. And in this video, I'm going to cover three things. One, what is unlawful display of a weapon, including the penalties? Two, what are some common situations that we see that type of crime charged, and what are some differences between more serious charges? And three, and most importantly, so stay to the end for this, are what are some ways to defend that very serious charge. So again, I put out these videos for information to help people. Hopefully you'll find it helpful. If you do, please like the video at the end. Consider subscribing to our channel because we put out 3 or 4 videos a week. I want to get as much information out there as I can to the public. So again, what is unlawful display of a weapon? And it's really called something different in the statute, but that's how we think about it. Think about unlawful display of a weapon as a gun for the most part. It can be other things. It can be knives and other things. But basically it means producing, showing, displaying a weapon in a way that causes reasonable alarm, that warrants alarm for the safety of others is the way to think about it. The statute is much longer and much broader. There's lots of ways to violate it, but the most common way I want you to think about it is basically showing a weapon with a way to intimidate someone or that might scare someone, right? And so it's sort of what an officer says it is, but that's the most common way to think about unlawful display of a weapon. For the most part, it's not a felony. It's a gross misdemeanor, maximum penalty of a $5,000 fine and 1 year in jail. And if you get convicted of it, you'll lose your concealed pistol license. So that's an extra added bonus penalty. If you get convicted of this type of charge, you won't be able to have a CPL anymore. So what are some common situations that we see unlawful display of a weapon charged, and what are some more serious things that could happen? Well, everyone's under stress right now. This is January 2021. I'm filming this. We're in coronavirus. We're in all the election mess right now. And so we see a lot of road rage. And so the most common situation that we see this type of charge is you get into a road rage incident with someone, someone cuts you off, someone thinks you cut them off, you're driving, you're afraid, you happen to have a CPL, and so you sort of show your gun. You don't point it at them, but you show, hey, I got a gun, back off. Well, that makes sense to you that that was to protect yourself. Oftentimes that person will call the police, and oftentimes you're going to get charged with unlawful display of a weapon because basically you showed a weapon in a manner sort of meant to intimidate. What could be worse than that situation? If the other person says you pointed the gun at them, that could be assault in the second degree, a major felony, a strike offense. Anytime we have a gun involved, it can get pretty difficult if it's in a conflict situation. Guns are very useful. We have a right to have guns to protect ourselves, but there's also a lot of broad laws to prohibit the behavior with guns. Another way we can get charged with unlawful display is just someone claiming that they saw the gun and they were scared of it. I mean, I've seen cases where someone brings their gun to work, they're showing the gun around, and someone misinterprets it, they get scared by it, they call the police, and the next thing you know, the person who got scared ends up getting you charged with unlawful display of a weapon, even though you had no intent to scare anybody. And so it's a pretty broad statute. There's lots of ways to run afoul of the statute. And of course, what it usually comes down to is someone claims you had a gun, someone claims you pointed the gun at them, and then at that point, they're going to charge you with a felony assault for pointing the gun at someone, or they're going to charge you with displaying a weapon if they didn't think you intended to scare them by pointing it at them, or maybe they won't charge you at all if they just don't think it happened or you didn't have a gun. But it's a very serious charge, and you need to reach out to an attorney. So how do we defend unlawful display of a weapon? Well, there are a bunch of ways to defend that. Number one, and this is written into the statute, is we can claim that whatever weapon we displayed was to defend against the present use of unlawful force. And so that's a little bit more strict than self-defense. In the car example, would showing the gun be defending against the present use of unlawful force? Well, maybe if they were pointing a gun at us, I mean, we're going to make that claim, but realize it's not quite, I was just scared, that's enough. Another possible statutory defense is that whatever we did was in our fixed place of business or abode. Basically, we can make an argument that, hey, if we're displaying a gun just like this, trying to defend our home, we have more of a right to like display a weapon to defend our home than we do if we're out in public. And also that can also apply for a fixed place of business. Also, if you're a law enforcement officer doing your duties, there's a defense to that. If you're a military person, there's a defense to that as well. So there are some statutory ways to defend. And if we run afoul of the first part of the statute and we don't quite meet the statutory defense, if we're close to it, we could still argue that to the prosecutor and say, hey, this was generally in defense. The statute, why may not specifically cover us? Well, it might. That's sort of the spirit of what we were doing, so we think that you should be lenient in our situation. Number two, another way that we defend these is just saying, hey, we didn't display a weapon. They might have seen a gun, but there was no reasonable fear or affront. There was no reason to be scared because I brought my gun to work and I was proud of it and I was showing it to someone. I wasn't angry. I wasn't acting out of sorts or mentally problemed. The person's reaction is unreasonable, so you haven't met the statutory definition. And then finally, number three is I just didn't do it. They were mistaken. That was a cell phone, not a gun. Because, from a distance, how do we know? And sometimes people just make up stories or they're so under pressure, they want to believe what they believe. So, if you find this video useful, please hit the like button, subscribe to our channel. We put out lots of videos to help people. And more importantly, if you find yourself in this situation, give our office a call. Again, we've been defending people for more than 20 years. I was a prosecutor for 7 years before that. We'll listen to what happened. We'll help you figure out what to do now, and we'll get you the best possible defense. So give us a call, and we'll be there for you. Thank you.